Okay, I believe we're ready for the next case. Let's do a quick sound check. This case is State of Iowa versus Brian McGee. I'll start with Mr. Sloven. Can you hear me? And I'd like to hear you.
Yes, good morning, Your Honor.
Thank you. And now Ms. Reddy, Vidhya Reddy, can you hear me? And I'd like to hear you.
Yes, I can hear you.
Okay, thank you. And as the appellant, you may begin, Ms. Reddy.
Thank you. I am Vidhya Reddy. I am here on behalf of defendant appellant Brian McGee. Mr. McGee appeals his conviction for operating while intoxicated, which was entered after a trial on the minutes in the district court. On appeal, he urges that this court should afford him a new trial, as the district court erred in overruling his motion to suppress a warrantless blood draw, which was obtained under Iowa Code Section 321J.7 at a time that he was unconscious. Defendant urges that suppression was required specifically under search and seizure protections of the Fourth Amendment and Article 1, Section 8 of the Iowa Constitution, because that collection of the blood sample was conducted without a warrant and without application of any exception to the warrant requirement. So specifically, it's well established that collection of a body sample for chemical testing is a search that is subject to search and seizure protections. And further, that a warrantless search is per se unconstitutional unless one of the limited exceptions to the warrant requirement applies. Further, the burden lies with the state to prove application of one of those exceptions. In this case, the state had below relied upon the consent exception, specifically looking to the implied consent statute under Iowa as providing actual voluntary consent so as to fall under this exception to the warrant requirement. However, for the consent exception to apply, the consent that's provided has to be actual voluntary consent. And implied consent laws don't create actual advance consent to future chemical testing. That's been, established under both Birchfield and Pettyjohn, and more explicitly confirmed.
Ms. Reddy, there's a lot of background noise. I don't know if there's anything.
I'm so sorry. It's the dog is close by and is moving around.
Maybe you could put him beyond the door, perhaps, and shut the door.
He's in his kennel, and I wonder if I put him outside, if it'll be louder. I'm so sorry. I apologize. Hopefully, it will stop. He's right outside the area, but hopefully that will stop. I apologize. Are you able to hear me now?
Okay. Yeah, problem's not hearing you. The problem's hearing the dog too.
Yeah, I understand. I apologize. So, it's well established that for the consent exception to apply, there has to be actual voluntary consent that's given contemporaneously with the blood draw. That time of the blood draw is the critical point in time, and that is emphasized both in Birchfield and in Pettyjohn. That's the point at which the inquiry is made. In the present case,
Ms. Reddy, this is Ed Mansfield. Let me try and kind of cut through some of this. Would you agree that under the federal Constitution, under the Fourth Amendment, we need to apply the plurality opinion in Mitchell?
Correct. Well, no, I'm sorry, I don't. I agree that Mitchell controls under the Fourth Amendment in a case involving alcohol, but defendant urges that Mitchell, by its terms and by its reasoning, has no application to a case like this one that involves probable cause for marijuana, specifically because of the fact that the window of time available for testing and for obtaining a warrant is much longer for marijuana than for alcohol.
All right. So aside from this issue about whether there was some reason to suspect alcohol in addition to drugs, we would be applying the plurality in Mitchell. But if it was clear that it's a drug case, we shouldn't apply Mitchell. Is that your view?
Correct.
Counsel, do you,
So
is it undisputed that Mr. McGee was unconscious at the time of the blood draw?
that he was unconscious at the time of the blood draw. So there's this issue about whether his condition had changed between, in that 12-minute duration between the certification that's required under the statute and the actual blood draw. We know in the interim period, his condition had changed, and there's no new certification or testimony from anyone, at the time of the blood draw that he remained in a condition unable to consent. But for purposes of the constitutional arguments, which is separate than that, the argument that the statute itself was not complied with for that reason. For purposes of the constitutional arguments, the terms of the statute themselves presume that the individual is unable to consent at that time, and therefore, by its own terms, the consent exception is not applicable. In terms of the exigent circumstances,
Ms. Reddy, this is Justice McDonald. Why doesn't the Finley case control the resolution of the Iowa claim that you're asserting here?
And I apologize, Justice McDonald, could you briefly remind me what the pertinent case?
I think in the Finley case, which has been controlling law since 1966, our court held that you could do a blood draw. I mean, it's essentially Mitchell, but 54 years prior or 53 years prior. So I guess why isn't that controlling?
I would suggest that our understanding of the pertinent exceptions and the requirements of the warrant requirement have evolved since in that 54 years. Specifically, I think there is some conflicting case law previously about, for example, is implied consent? I mean, it talks about consent, so is that constitutionally adequate consent? And certainly, the U.S. Supreme Court has since clarified and made clear that it's not.
Let me ask you this, maybe not related to the merits, but you didn't mention Finley in the briefing, correct?
I don't believe I did.
So you're raising an Iowa constitutional claim, and it seems to me that the most relevant case, that's directly on point, is this Finley case. And I guess I don't understand why you're asserting a constitutional claim, but then not presenting the court with the controlling authority on that point.
Well, I'm not sure that Finley is controlling. I mean, I obviously did not see it at the time that I was briefing the case, but certainly I would suggest that Pettyjohn demonstrates the current analysis on this issue under the Iowa Constitution. And Mitchell, by its own terms, does not apply even under the federal Constitution. So this particular search is prohibited even under the federal Constitution. The exigency exception does not apply. Mitchell, in fact, reaffirmed the longstanding recognition of the fact that the court is not entertaining a possibility that dissipation of evidence within the bloodstream is a per se exigency. In Mitchell, they reaffirmed that aspect of McNeely. They simply carved out a specific limited exception in the context of a blood alcohol test. And then in Pettyjohn, we recognized, that same limitation. And Iowa Constitution historically has been more protective than the federal Constitution for search and seizure claims, and has limited exceptions specifically to the purposes that they serve. And it's quite clear that in the present case, there was no attempt to prove that any sort of
Can I push back on you a little bit on that claim? And I know the briefing generally goes something like this. The Iowa Constitution has historically been interpreted to provide more rights. And then the cases usually cited are dissenting opinions from the United States Supreme Court on why we should adopt a more liberal approach. But there's no discussion of the actual cases. So in this case, we have a controlling case, Finley, I think that is not, that predates Mitchell. It's, you know, I guess my beef here is that it seems like we want, as you're presenting this, the Iowa constitutional history starts in the year 2000. And there's really no discussion of a lot of controlling doctrine. And I guess my question is why aren't we discussing those cases? And maybe just a practice pointer, I guess, which
Sure.
is if you're going to keep making these claims, and I think you should, as the appellate defender, right, you have to present us with the Iowa authority that's controlling.
Sure, I understand.
Right.
I understand that. Yeah, absolutely. You know, I guess my point is that Finley is not controlling. I mean, what's controlling is is Pettyjohn, and is the reality that it has to fall under a constitutionally valid exception, and our understanding of those exceptions.
But wait a minute. But Pettyjohn, this is Ed Mansfield. I'm sorry. Pettyjohn, both Justice Wiggins for the majority and Chief Justice Cady in the concurrence were very clear and said that it's limited to voting. There were some of us in dissent who thought it might have broader implications, but normally you follow the majority opinion and not the dissent, right? And they said it was limited to voting.
Well, I think that that's not entirely correct. I mean, the limitation to vote, so there is certainly that language, and there is this caution that it applies only, that it's decided only in the context of voting. But as pointed out in the defense brief, what that refers to is the conclusion that Pettyjohn reached under the consent issue, that the coercive nature of the consequences of refusal under the voting while intoxicated provision rendered the purported election between consent and refusal involuntary. But the consequences of refusal under the operating while intoxicated statute are different than the BWI statute. And Pettyjohn doesn't reach the question of whether those other consequences under the operating while intoxicated statute would render the purported election between consent and refusal in the OWI context inherently coerced and involuntary. So that's the piece that is specifically limited in Pettyjohn, and Pettyjohn certainly doesn't speak to the question of whether, in the OWI context, the implied consent statute prohibits or controls, that issue of consent.
But in any event, Finley, under both the US and Iowa Constitution, as I read it, doesn't go under implied consent so much as it goes under exigent circumstances. It says, if the officer ordering the intrusion, as here, reasonably believed he was confronted with an emergency, a situation in which the delay necessary to obtain a warrant threatened the destruction of evidence, he can rightfully order the blood withdrawal and complete the test. That sounds kind of like Mitchell. I mean, it's almost like, 50 years before we were predicting what the US Supreme Court would do in Mitchell, right?
Well, yeah, but I think that has to be in context of, in this case, there's no suggestion that anyone believed that a blood draw wouldn't, or that a warrant could not be obtained in time before that dissipation occurs. I mean, the testifying officer quite straightforwardly, says, nope, there was nothing stopping me from doing that. We just didn't. It's our policy not to request a warrant unless, not to request a warrant in an OWI case unless there's a fatality. So, so I think this suggestion, that controls is perhaps
right. And I intend to ask Mr. Sloven about that. You're correct.
Yeah. And then in terms of, how Mitchell alters that, they conclude that in this limited context of blood alcohol testing, that where we have, it's very well established, this very limited time window, that in a circumstance where that is further constrained by something, that 2-hour time window, that is going to establish a necessary exigency, but that doesn't apply to marijuana.
You may wrap up, Ms. Reddy.
Thank you. With that, I would request that defendant be afforded a new trial.
Thank you. Mr. Sloven.
Thank you, Your Honor, and may it please the court, counsel. Good morning. Louis Sloven on behalf of the state. It's good to be with you all this morning. Justice Mansfield, I want to start with the question that you forecasted, which is it a problem that this officer testified that it was their policy not to seek a warrant in cases like this? I would say that it would be a problem if we were proceeding under 321J.10A, which is the statute that specifically requires that the officer reasonably believe that getting a warrant was impractical. That was the holding of Harris, saying that the county attorney explaining the reasons why it was impractical and the officer relying on that, that's not good enough. That statute specifically requires the officer harbor that belief. That's different from this context where the inquiry is an objective inquiry into, and Mitchell says this very clearly, and it's also in Johnson, which came before Harris. Could a reasonable officer believe that obtaining a warrant would be impractical? This is an objective inquiry rather than a subjective one. So the officer's understanding of their policy, that's not relevant to the question of whether this was objectively reasonable. And all this goes on a broader level. Implied consent is not the same thing as actual consent. It would be that's not the argument that we were making, and I don't think that's a defensible view of implied consent. It applies whether or not the person has ever been told that OWI testing even exists, or whether they even know that OWI is a crime.
But before we get to implied consent, regarding the exigent circumstances argument, or the Mitchell version of exigent circumstances, or the Finley version of exigent circumstances, wouldn't it make sense to do a remand and allow each side the opportunity to present the evidence under that? Because it's sort of an odd version of exigent circumstances, what the US Supreme Court delineated in Mitchell. It's kind of, I think we would all agree it's tilted in favor of the government, but how much it's tilted, certainly the parties didn't know that at the time they argued the motion to suppress. Wouldn't a remand make sense?
It would make sense in some circumstances, Your Honor. Now, Mitchell requires two separate showings. The defendant, now I wouldn't say the burden starts on the defendant. It's important to clarify. This is why our notice of additional authorities cited those 2 paragraphs of Richards. That's the first one we listed, which says, I think their interpretation is right, that first the burden's on the government, as it always is in defending a warrantless search or seizure. The government has to show that the circumstances in Mitchell are met, that this is a blood draw on an unconscious or incapacitated OWI suspect receiving medical treatment. Just like for search incident to arrest, burdens on the government has to show that this is a valid arrest and a search incident to it, right? Then there is an opportunity for the defendant to show that the search is still unconstitutional. Then the burden shifts. The defendant has to show 2 things. First, that blood wouldn't have been withdrawn for medical treatment purposes anyway. And second, that a reasonable officer could not have believed that attempting to apply for and obtain a search warrant would have introduced an impractical delay in gathering this evidence. Now, that is what Mr. McGee's advocacy was focused on below already. And we already have the record evidence, not only from the motion to suppress hearing, but also from the minutes of testimony establishing the other exigencies that were inherent in this situation, which align extremely well with what's described in Johnson, not the 1965 Johnson, although that case is important here too. The 2008 Johnson, talking about this was an accident, there's an unconscious driver, there's injuries to attend to, traffic to direct, all of these things that officers had to deal with. They even had to call in an officer who was on call, who had to drive in 30 to 40 minutes to the hospital to do the blood draw procedure. So I think that on this record as it already exists, this court can say it's just impossible to disprove that default exigency that exists when you have an unconscious OWI arrestee. Now, if this court disagrees and
Counsel,
thinks—
is the state somewhat arguing here for what I think Justice Thomas was seeking in his special concurrence in Mitchell, which is in a situation like this, it's always an exigent circumstance, and we should just sort of draw that bright line?
I think that would be permissible. That certainly seems consistent with Finley. I think the Iowa Constitution would permit that. Now,
well, it's just going to be
wouldn't.
wrong, wouldn't it? I mean, you don't have an exigent circumstance when you're trying to find traces of marijuana. Marijuana stays in the blood, we all know, for weeks. If marijuana is what you're looking for, there is absolutely no exigent circumstance in this case.
Well, I have some thoughts on
challenge me.
Yeah, I have some thoughts on that, Your Honor. The first is that the inactive metabolite does, not the active metabolite. That's the delta-9 tetrahydrocannabinol. If you look at the test results and the minutes of evidence, you'll see that that is present in the defendant's blood. That metabolizes much more quickly. Now, in 2018, when this happened, we're in a state on the timeline between Childs in 2017 and Newton in 2019. There is a due process challenge to the any amount of a marijuana metabolite alternative of OWI lurking out there somewhere. Recognize that it may exist, but hasn't yet been brought to this court. So even if we're just talking about that, I think in that particular window, there is an exigent need to get the evidence of something beyond that, because who knows if that's going to be a valid basis for prosecution at that point. But also, I would point to Strong, Iowa 1992. If you look at the citing references to Strong, you'll find a New Hampshire case called Steimel. And I think the analysis in that case is particularly on point, that if you're looking for evidence of OWI, the same crime is committed if there's any amount of you're looking for evidence of the operation of the vehicle while intoxicated, and the specific intoxicant is less relevant you're looking for evidence of the same crime, and I think you can test for any intoxicant. Now, in this case, on the facts, the officers had evidence of the erratic driving that I think that can be fairly characterized as not solely necessarily attributable to, or not necessarily solely attributable to marijuana.
Let me try and, Mr. Sloven, I think I understand. Let me try and sum up what you're saying. If all the officers had to work with was the erratic driving, the high rate of speed, and the broadsiding of the other car, they would be able to, based on that, check for alcohol, right?
Right, or other potential intoxicants.
And your point is they're not in a weaker position just because he smells of marijuana.
I think that's right, Your Honor. I think that the marijuana is one potential explanation. It doesn't rule out others. It doesn't rule out additional intoxicants. And I think that especially the excessive speeding and the failure to yield left turn, there's all kinds of different explanations for that. And some of them, I mean, excessive speeding is not, I would agree with what you're saying, that marijuana, the scent of marijuana doesn't weaken the probable cause showing for other potential intoxicants, especially when the manner of collision is excessive speed, which is something you might not always associate with marijuana.
Counsel, sorry, you go ahead, Justice Waterman.
Thank you. Counsel, is Finley good law after Pettijohn for purposes of the Iowa Constitution?
I would say that it is, or at least should be. Pettijohn has that footnote that says, we're unsure about how this would apply in the instance of an unconscious voter. There might need to be some additional showing of exigent circumstances. Now, I would agree that Johnson, 2008 Johnson, does say that it adopts a view of Schmerber that you don't always have a per se exigency just from the metabolization of alcohol in the bloodstream to support any warrantless search or seizure of a chemical sample. Now, I think that as we describe in our brief, when you start to limit that to the least intrusive method available, and when you, I think that can shift the analysis in a way that makes certain kinds of minimally intrusive OWI testing more objectively reasonable in a way that can sustain a more categorical exception that provides a bright line rule. I think that when you look at a lot of this analysis is just missing in Pettijohn, which I think is a big problem for the validity of Pettijohn.
Yeah. And your brief makes a very persuasive argument that Pettijohn was wrongly decided. Is this the case to overrule Pettijohn?
Well, so I point out that the reliance on, so the argument that Finley no longer applies and controls is that Pettijohn has somehow overruled or qualified it. So that brings it up. I'd also point out that one of the problems with Pettijohn is that it reaches that constitutional issue, even though, I mean, the state said the statute requires, it creates a right of refusal and then requires the consent or refusal choice to be voluntary. So if you have a conscious driver making a consent or refusal choice, you're never going to actually reach the issue in Pettijohn. You're just going to have to assess the voluntariness of that choice. And there's parts of Pettijohn that are pertinent to that. But the issue is really squarely presented here, where we can't have a choice by the driver, and where you have to consider the reasonableness of the search in the absence, or in a situation where actual consent is impossible. So I think that this is one of the few instances where you will have to consider the validity of that portion of the holding of Pettijohn. I think it's also possible to say what Pettijohn says and that it's only limited to boats, but then it continues to lurk in the wings for courts to have to deal with. The alternative is to reach Pettijohn in a case like Kilby, where you have to discuss the implications of recognizing the constitutional right outside of the validity, outside of the admissibility of the test result. But I think that that's more of a stretch than this case, where Pettijohn was specifically relied upon in the district court as the basis for finding that this application of 321J7 is unconstitutional, and specifically relied upon here as a basis to say that Finley is no longer the controlling law under the Iowa Constitution.
Is there anything in the record to show that it was not possible to get a warrant in, say, half an hour?
Well, so we have the minutes of testimony, and we have the officer testimony about what was done and about.
But there's no reason to assume that a warrant couldn't have been obtained in relatively short order.
So what we do know, so beyond what we actually have in the record, we have what this court has already recognized and what we already know about warrants and warrant applications, that they take time.
I understand the legal, presumptions and et cetera, but factually there was no showing that you couldn't get a warrant timely.
Well, we don't have any testimony from the officer about the amount of time it would have taken to get a warrant in this particular instance in this county at this time. What we do have, and one of the reasons that Mitchell makes this a rebuttable presumption of reasonableness, is because every warrant application takes time, that it takes time to do it meticulously enough to withstand further challenge, to comply with the applicable statutes. You need to gather the information from from the people who made those observations firsthand, swear them out, present them to a magistrate. There's also, because it needs to withstand further challenge, there's a need to review it and dot all the I's and cross all the T's.
Yeah, and
That
all the
also takes
case
time.
law on exigent circumstance talks about how fact-based it is. When exigent circumstances first surfaced in the 70s, it was all about how fact-based it was, and now we're saying we're going to employ legal standards. I mean, I think that's your argument. What you're saying is, no, we don't.
Justice Apple, we lost your voice. You just were talking about what Mr. Sloven is arguing.
Okay.
There you go.
Am I back on? Mr. Sloven, are you confused by? Okay. Well, I was saying historically, exigent circumstance was fact-based, and there's a lot of case law, blah blah blah, and now, including the United States Supreme Court recently, they're moving away from the fact-based nature of exigent circumstance to have some categorical legal rules. You're relying on categorical legal rules, I think, but that takes us far away from the original origins of exigent circumstance. And I guess I was just trying to clarify that there's nothing in the record factually that suggests you couldn't get a warrant. What you're relying upon is legal principles and presumptions.
Well, to a certain degree, we have the record establishing the other duties that officers were shouldering during that relevant time, and that the blood draw here actually didn't happen until 10 minutes outside that 2-hour window. And I see my time's about to expire. Your Honor, if I can answer the question and then
Yes,
briefly.
please wrap it up. Thank you.
But I take your point more broadly. We develop these legal rules about what circumstances more broadly qualify as exigencies after a series of cases that find fact-specific exigencies. That's how we develop the rule that search incident to arrest is always reasonable of the arrestee's person, even when the arrest happens on the steps of the courthouse on a slow day. We have the general rule of the automobile exception. That's a generalizable exigency without the need for fact-specific showing about what the warrant procedures were like in that county or the particular mobility of that specific automobile. And what I'm getting at is that we're at a point where what we know about dissipation of intoxicants in the bloodstream, what we know about what has to be done every single time you fill out a warrant application, plus the availability of ex post review through challenges after the fact, and the everything that we know about this class of case comes together to warrant a conclusion that this is categorically reasonable, subject to a rebuttable. There's an opportunity for the defendant to make a showing that under these facts, no reasonable officer could have said that applying for a warrant wouldn't have created an impractical delay.
Yeah, you're really underestimating the value of the warrant requirement, it seems to me, because there's a substantial cost when you don't have warrants prior to the actual intrusion.
Well, I just as a brief one-sentence answer to that, a lot of that value comes from the particularity and the scope of the warrant, which is really not a concern here. And so I think that I wouldn't discount the warrant requirement globally, but I would say in this specific context, the interest served balanced against the minimal privacy interest that the warrant requirement serves here makes this class of searches presumptively, if not categorically, reasonable. Thank you.
Thank you. Ms. Reddy.
Thank you. So if I could briefly touch on Finley again, I do want to emphasize I've had the opportunity to refresh my recollection about that case. And I do see, again, it's specific to alcohol. There's nothing in that case that goes beyond alcohol. And in light of what we know about alcohol across the board, it has a much shorter window of time than for marijuana or for other controlled substances. And that limited window of time was central or is central to this finding of exigency. I mean, Finley itself talks about, if the officer, if there's a showing that the officer believes delay will result in the loss of the vital evidence necessary to convict. And again, that was an alcohol case. There's nothing in the present case that suggests anyone believed that obtaining a warrant was not feasible in a timely manner in the present case.
Counsel, can I ask you a similar question that I asked Mr. Sloven, which is in light of what arguably is a very complicated process now that the police would have to go through to sort of make their case as to exigency. Under Mitchell, it seems as though the exigency requirement is being watered down. With the time sensitivity that's there, what is wrong with a bright line categorical rule that says in a situation like this, when someone is unconscious, that the police should have the right to draw blood?
Because it is not constitutional, right? I mean, the exigent circumstances exception applies on a case-by-case basis that depends on the particular facts. What Mitchell said is in the context of alcohol impairment with an unconscious driver, we've got kind of fixed facts in terms of, we know there's this limited 2-hour window in every alcohol case, right? We know that that's a pretty tight timeline, and that the fact of an accident or of an unconscious driver needing medical treatment is going to tighten that up. And so we put our thumb on the scale in that particular circumstance and say, in these circumstances, it's generally going to be infeasible to obtain a warrant within.
Ms. Reddy, I want to push back a little bit on that. Aren't you assuming that there is no alcohol? I mean, right now, you wanted just for all of us to kind of take notice of the fact that alcohol, you had some qualifications about a shorter period of time for dissipation, but also isn't it reasonable to assume that the smell of pot is pretty strong and might oftentimes overpower the smell of alcohol? And so if pot is the thing that's getting some attention, you can't do a breath test. So you only ask them to take one test. And in this case, I know we don't have consent, but I think aren't you underestimating the fact that, we shouldn't certainly say if pot is what's at issue, then they get anything alcohol related, we don't consider, and nor does our case law apply. Isn't that a stretch?
No, I think it's entirely speculative to suggest that this individual might have had any sort of alcohol. There's nothing connected to that. Absent, it's the smell of marijuana that gave the officers probable cause in this case. Absent that, there is witnesses that talk about, quote, erratic driving, no description of that. That's not observed by officers to indicate that that's anything beyond, carelessness or anything else. And the fact of an accident, right? So, and the fact that the individual has engaged in traffic violations, has violated rules of the road, or was maybe engaging in carelessness does not establish the nexus to a controlled substance, whether it's alcohol or anything else. It's only the smell of the marijuana that gave the officers probable cause to believe that this was based on some sort of impaired driving. Absent that, there is not probable cause of, if they did not have that smell of marijuana in this particular case, with no other facts, only those things that are in the record, they do not have probable cause of impaired driving in any way. All they have is an accident and traffic violation. Except
on the record, let me just say, the record is silent on the alcohol issue. I think. Correct me if I'm wrong. It doesn't. There's nothing in the record that specifically suggests alcohol one way or the other. Do I have that correct?
You do, and it's a state's burden to demonstrate. Right?
Well, of course, if there was a warrant, we would know. If there was a warrant, you have to put down the basis for the search. And one of the marvelous things about a warrant is that you have to outline the reasons and the scope of the search. And had we had a warrant here, we'd know the answer to whether they're looking for alcohol or pot. And quite frankly, we don't have a warrant here.
Yeah, I think that's exactly right. I think when we're, and I do see.
You may wrap up.
Sure. In effect, I would suggest that that when we're applying an exception, to the warrant requirement that requires probable cause plus something else, you have to look at what the probable cause exists for, and that is what defines the parameters of whether the exception applies or not. And in this case, there was probable cause only for marijuana impairment. And so it's only marijuana that, the rate of metabolization, the fact that you don't have to prove any specific amount, but just any amount at the time of the operation, unlike alcohol. that controls our understanding of, when the exigency requirement is satisfied. And so because of that, it does not apply. And on that basis, defendant would respectfully urge that the suppression motion was erroneously denied in the district court. Thank you.
Thank you, Ms. Reddy and Mr. Sloven. The case of State versus McGee is hereby submitted. The court is going to take a 15-minute break until 10:45, and we will reconvene for the case of No Boundary versus Hoosman.